Well, welcome to the webinar on structure and acquisition transactions. I'd say presented by Business Law Section Council, the ISBA. As Chrissy said, I'm a member of the Business Law Section Council and on the UCC and LLC subcommittees, but I spend most of my time doing M&A work. And this being a statewide webinar and being toward the end of the CLE year, I assume we have a wide variety of expertise in these matters. So for this reason, I'm going to cover a lot of basics, but also try to get into more depth in certain areas. Feel free to ask questions through that chat box during the presentation. I'll try to answer them during the presentation. If not, I'll do my best to answer them after the presentation's over. It's a disclaimer for any non-lawyers, or I guess any lawyers on there. This isn't legal advice. If you have specific questions about specific circumstances, please consult your attorney. So today I want to go over some certain structure basics, the three usual types of acquisition structures: an asset acquisition, stock acquisition, and discuss some merger types. And then go over the primary considerations in structuring your transactions. A lot of it is tax, and there are a lot of commercial matters that are involved as well. In an asset acquisition, the buyer acquires only specific assets of the seller, and the buyer assumes only specified liabilities subject to successor liability. For these reasons, a buyer generally prefers an asset acquisition to other acquisition structures. The asset acquisition provides flexibility to pay for only wanted assets and to avoid those unknown or undisclosed liabilities. And the buyer usually gets better tax treatment as well. We'll discuss that later. The seller, on the other hand, doesn't want to be left with those known or unknown liabilities or any unwanted assets. Since the buyer is only acquiring certain assets of the seller's entity will continue in existence after the sale and remains liable for those liabilities. The seller also potentially receives worse tax treatment in an asset acquisition. Discuss that later. For the buyer, just one caveat would be, of course, don't forget to purchase assets you actually do want in an asset acquisition. Although a buyer prefers an asset acquisition so it doesn't get caught with unintended liabilities, do remember that successor liability is still an issue. Successor liability is too voluminous to really discuss here in this presentation. Just remember that certain types of claims, especially around employment, environmental issues, ERISA or benefit plan issues, product liability, taxes, sales and use tax, are still possible when a buyer acquires in an asset acquisition. The mere fact that the APA says you aren't assuming those liabilities isn't necessarily enough. An asset acquisition, at least from a document standpoint, is more complex, so the closing involves a few more pieces of paper. Each specific asset needs to be transferred and each liability assumed, so formal transfer documents like assignment of assumption agreements, bills of sale, a lease assignment assumption, IP assignments, deeds, groundwater hazard statements, decks of value are all needed, depending, of course, on the type of assets that are being transferred. Stock acquisition is a little bit more straightforward. The buyer is just acquiring the outstanding stock directly from shareholders, so every individual shareholder is a seller. Now, in the end, the buyer ends up with a subsidiary, and all of the assets and liabilities are set down in that subsidiary. The seller usually prefers a stock acquisition because the seller can unload everything, all those liabilities, whether known or unknown, and usually gets better tax treatment. And again, the buyer prefers an asset acquisition. In a stock acquisition, though, each shareholder has to sell his or her own personal property, the shares of the stock. So unless you have drag-along provisions in a shareholder agreement, something like that, or you're acquiring most of the stock of the target company and then following along with a short form merger or something like that, you need every stockholder on board for the sale. Since just shares are being acquired, it's a lot less complex from a document closing standpoint than an asset acquisition, but it can be more complicated if not all the shareholders are on board. And then you have some mergers. The usual forward direct merger is where the merged entity, the target company, merges into the buyer, the surviving entity. By statute, the surviving entity gets all assets and assumes all the liabilities by operation of law. Iowa Code 490.1107 and the Iowa Business Corporation Act is one of the statutory provisions that sets forth what the effect of the merger is. In every one of our entity statutes has a different provision on this. So the merged entity ceases to exist, the surviving entity continues. You have to follow the merger statutes of both the surviving entities, state or entity type, and the merged entity, state or entity type, and make filings in both of those states. Usually an articles of merger are required in each state, and you have an agreement or a plan of merger. Similar to stock acquisition, it's pretty straightforward. Merger can be preferred though because, unlike a stock acquisition, you usually only need a majority vote from the shareholders of the target company. We'll discuss more on that later. Practically, just because most private companies have small enough groups of shareholders to deal with and public companies do not, a merger is more common with the public target, while a stock acquisition is more common with the private target company. You can also get into a couple more complicated merger transactions. The forward triangular merger is pretty much the same as the forward merger, except the buyer drops down a merger sub, so it already, before the transaction, creates a wholly owned subsidiary, and then the target company merges into the merger subsidiary. So like a stock acquisition, the buyer is left owning a subsidiary that has all the assets and liabilities of the target company. In a reverse triangular merger, the buyer again drops down a merger subsidiary, but in this instance, the merger subsidiary merges into the target company. The merger subsidiary here is sometimes called a catalyst just because it shows up for a small amount of time and is used to affect the transaction. It's just used a lot in public company transactions. You have a lot of benefits for third-party and internal consents. Since the target company has just undergone a change of control, hasn't transferred its assets, and we'll get into more on that later. I want to talk just really briefly about a couple alternatives. They're not acquisition transactions per se, but if you're really looking just to change the form of your entity or the jurisdiction of your entity, do remember that conversion and domestication are out there. Similar to a merger, the governing statutes of both jurisdictions must be complied with. So if you're changing a Washington LLC to an Iowa LLC, for example, you need to follow the conversion statute of Washington and Iowa. A subset of conversion is domestication, where, like in the last example, you're just changing the jurisdiction of organization, Washington to Iowa, but it still remains an LLC. In some states, most states still call that conversion, but note our LLC Act, IROLCA, contains a separate provision of that called domestication. So those are just the background, the types of structures we're talking about. Really, I can group the types of considerations when choosing which acquisition structure to use into two groups. One is tax considerations, and there are a lot of them, and then commercial considerations. On the tax side, this is a very brief overview of what's a very complicated discussion of tax considerations. And there are whole semesters and whole careers dedicated to this stuff. So this is just a general overview of what's involved in acquisitions. It's enough to make you dangerous, so I'd strongly suggest in any acquisition tax structure be planned with a tax counsel or accountants to understand the full implications of what will occur. The next few slides deal with income tax considerations for asset acquisitions, and we'll talk about stock transactions as well. For income tax purposes, a forward merger and a forward triangular merger are treated the same as an asset acquisition. So if the assets look like they're transferring from the hands of one person to another, the forward merger, the asset acquisition, they're treated the same. A reverse triangular merger, however, which looks more like a stock transaction, is treated for income tax purposes like a stock acquisition. For time considerations, you really don't have time to get into tax-free reorgs. Generally in your private company acquisition, which is what I assume most Iowa practitioners deal with, the consideration paid by the buyer is going to be some combination of cash and promissory notes, simply because the buyer's stock is not freely tradable. If the consideration does include the buyer's stock, the acquisition may in that instance qualify as a tax-free reorg. This presentation really just discusses the tax consequences if cash and notes are used. Although the use of stock as consideration is generally outside of this presentation, if buyer stock is used as consideration, besides the tax-free reorg pieces, just remember that you are issuing stock, you are issuing securities in that instance, so you do need to comply with federal and blue sky securities laws. You also might have, if you're a public company, some New York Stock Exchange and other regulations. And if you have preemptive rights and other governing document obligations, you're going to have to follow those as well. So in an asset acquisition, again, the forward and forward triangular mergers are treated the same. An asset acquisition is generally pro-buyer. So the buyer receives a cost basis in the assets it acquires in the transaction. This gives the buyer greater depreciation, amortization, and reduces gain on later sale. The cost basis for the buyer is the purchase price, cash, notes, assumed liabilities. And it's a generally pro-buyer because the buyer gets a stepped-up basis. And that is, the cost basis is higher than what the fair market value is and higher than the basis the seller had in the assets. It should be noted, if the cost basis is lower than fair market value of the assets, then the buyer would get a step down, and then all else being equal would prefer stock acquisition. A C Corp seller is going to prefer a stock acquisition for reasons discussed later. A seller that's taxed as a partnership or an S corporation or a disregarded entity where you don't have two different levels of tax generally isn't going to mind an asset sale at this standpoint, just because there's no corporate level taxation. However, the seller owners are going to care about purchase price allocation, and which should be part of your APA, and I'll get to that later. So the seller in an asset acquisition, if it's a C corporation, is going to recognize income and pay taxes on it between the difference of the amount realized, the cash, notes, assumed liabilities on the sale, and the basis the C Corp had in its assets. And then if it's a C Corp, the owners are going to recognize gain on any distributions the C Corp later makes. So if the seller is a C corporation, pays entity level tax, it's going to recognize income on the difference between the amount realized and its basis and assets. In most cases, for the owners, when they receive a distribution, it's going to be treated as a liquidation of the C Corp. So they're going to pay tax on the distribution of the sale proceeds. So it's like the seller's stockholders have basically sold their stock in exchange for the sale proceeds, so they'll just have capital gain. If it's an S Corp, partnership, disregarded entity, then they're going to, without the C Corp level taxation, they're going to recognize gain on that amount realized and then regardless of whether distributions are actually made. Okay, still dealing with the asset acquisition here. So in an asset acquisition, the amount of income and the new cost basis of the assets in the buyer's hands are determined on an asset by asset basis. So you have to figure out, what's the equipment, what was paid for inventory, what was paid for goodwill. And you're going to want to specify that allocation of assets in your purchase agreement for tax purposes. You really want to make sure that the buyer and the seller utilize the same purchase price allocation after the sale. And the buyer and these non-C Corp sellers, the partnership, S Corp, disregarded entity owners, are at odds over this allocation. So if practical, I mean, if you know what the asset values are or can agree on the asset price allocation at the closing of your transaction, you could simply add a schedule to your purchase agreement to figure this out. If not, the seller or the buyer, usually buyer, can prepare an allocation within a certain period of time and give the seller a period of time to object to that allocation. The seller that's a C Corp usually isn't as concerned about the allocation because the tax rates for C Corp for ordinary income versus capital gain are the same. But again, the S Corp, partnership, disregarded entity owners will care. These owners are going to prefer an allocation to capital assets that has no depreciation recapture, no ordinary income tax treatment, stuff like land or self-developed goodwill. Well, the buyer is going to prefer something that it can depreciate in a short amount of time, things like machinery and equipment and inventory. So in drafting the purchase agreement, just remember this is an issue that's out there and that the allocation is something that should be agreed upon at closing or a method of agreeing upon at closing, because you really do need to treat you really need to treat the allocation the same for both the buyer and the seller. Again, we're dealing with an asset acquisition here. And this is some miscellaneous considerations. Really, a buyer is generally not liable for seller's past taxes in an asset acquisition. Again, the seller still exists. It still has its own liabilities unless assumed by the buyer. But this is one of those areas to be mindful of successor liability. In Iowa, a buyer is going to be held liable for seller's unpaid sales or use taxes unless the buyer can make a good faith showing that no taxes were owed. To do this in Iowa, you can get a statement from the Department of Revenue, a tax clearance letter, or you can get a certified statement, an affidavit of no taxes due from the seller. Also, always remember to keep FIRPTA in mind if you're dealing with real estate. FIRPTA is Foreign Investment and Real Property Tax Act. If you're buying property and the seller is a foreign entity, a buyer is usually required to withhold 10% tax. And if you don't, you can be responsible. So it's very common in any transaction involving real estate to get a FIRPTA certificate saying that the seller is non-foreign. If there's any pro for a seller in an asset acquisition from a tax perspective, it's that it gets to keep its net operating losses, I guess, unless it specifically transfers those in the purchase agreement. The tax considerations in a stock deal are just like a stock deal, more straightforward than the asset deal. Stock acquisition is generally pro-seller. The shareholders just recognize their gain or loss on the sale of the stock. There's no corporate level tax. But the tax basis of assets of the target company remain unchanged for buyer. So instead of that stepped up basis that the buyer got in an asset acquisition, the basis in the assets remains the same, and the buyer just gets a cost basis in the stock. And, I mean, that's theoretically helpful if the buyer later sells the stock, but in a lot more instances, a buyer is going to prefer the increased basis in the assets for its depreciation purposes. In a stock acquisition, the buyer is acquiring the seller as a going concern. So it gets those net operating losses that the seller had in an asset acquisition. These elections are, the mechanics of them are too complicated to go over in this transaction or in this presentation, but just be aware that in certain circumstances, parties can treat a stock acquisition like an asset acquisition for U.S. income tax purposes, which would give the buyer a stepped-up basis in the assets. You can do this through a 330H10 election or a relatively new 336E election. In either case, if you have a corporate seller of a C Corp, the subsidiary is a C Corp stock, or there are S Corporation shareholders, and they sell 80% or more of the target company's stock within a 12-month period, you can use these elections. Under 338H10, the buyer used to be that the buyer had to be a corporation to be able to do the election. That's not a requirement under 336E though. And remember, for the stock purposes, reverse triangular merger was treated the same. So there are the taxes that, the income tax results. You also have to deal with the sales and use taxes of the target company, and you have to deal with potential transfer taxes involved. So as a general rule, transfer taxes are usually the responsibility of the seller, though you can always vary this by the contract. Transfer taxes usually do not apply in a stock sale. You're just selling the stock. Though I understand there are a few states out there that have some stock transfer taxes. And there are other states out there that have real estate transfer taxes for selling a controlling interest in real estate. So you always want to consult local counsel. Mergers are treated for Iowa sales and use taxes the same as they are treated for federal income taxes. So forward merger or the forward triangular merger, it's like an asset sale, and the reverse triangular merger is like a stock sale. In Iowa, there are a couple of casual sale exemptions, or I guess it's one exemption, couple ways to hit it, where sales, use, transfer taxes generally aren't going to apply to the transfer of the assets in an asset acquisition. If you've got 2 or fewer sales within a 12-month period, you can do that. That's pretty narrowly construed. Or you can have a liquidation of a business that's required to hold a sales tax permit in those instances, and you're not paying sales tax on the transfer of the assets in Iowa. Casual sale exemption, though, isn't available for real estate or for vehicles. Vehicles are subject to registration, so if you have a lot of vehicles, consider those taxes and those retitling fees, which are usually a buyer's issue, in creating your acquisition structure. And then real estate has its own exclusions for transfer taxes, but usually the transfer of real estate is in an acquisition going to be taxable. So those are the primary tax considerations. There are also commercial considerations involved in structure and acquisition transactions. I've broken these down in this presentation to timing, which really kind of involves all of these things. Third-party consents, which can be both contractual consents and then regulatory consents. And then you have internal consents. What are the target company and the buyer required to obtain from their shareholders, board of directors, to go forward with the transaction? As discussed previously, an asset acquisition is theoretically more complicated and time-consuming. Each asset is being transferred, each liability is being transferred, so you have more documents at least. An asset acquisition can also involve potential Warren Act notices or bulk sales law compliance, which can take time. The Warren Act can require certain procedures and notices if the seller is a certain size and lays off a certain percentage of their workforce and the buyer isn't hiring those employees. In some states also, but not Iowa, there are bulk sales laws that require notices to trade creditors before a deal closes if the creditors won't be paid off as part of the transaction. Like discussed previously, stock acquisition has the potential of being really the quickest transaction, but if you have shareholders who hold out or there are change of control provisions and material agreements, that won't be the case. It can also take a buyer longer to perform due diligence in the stock acquisition, since the buyer ends up with all of the seller's liabilities, albeit in a subsidiary going forward. Then there's a merger. It's kind of somewhere in between. Merger has the potential of moving quickly. You don't need everybody on board from a shareholder perspective, though you have to do shareholder meetings. But it really depends on the direction of the merger and which state's laws you're dealing with. And you may need similar third-party consents as in an asset acquisition, as I'll discuss in a second. That's kind of up in the air. Third-party consents can really dictate what type of acquisition structure you want. In an asset acquisition, a contractual consent is going to be required for basically any anti-assignment provision. The only carve-out would be those where it says you can't assign unless the buyer is assuming the liabilities. In a stock acquisition, you only have to worry about change of control provisions. Those are can be pretty narrowly construed, so unless it really is the obligation of the seller of the target company to get a consent when the owners of that company are changing, you're not going to need a consent for a stock acquisition. In the forward merger, anti-assignment might be triggered. It's really an open issue in Iowa law. The assets are transferring, but they're transferring by operation of law. So some courts treat that as an assignment, some don't. If a provision talks about not permitting transfers, it seems a little bit closer. I mean, that's the type of language that's discussed in the effect of the merger in the statutes. And a transfer by operation of law sounds a lot like a merger. And then, of course, if the provision prohibits a change of control, you're almost certainly going to have to get consent in that instance. And a reverse triangular merger, where the target company isn't transferring any assets and is the survivor, so it's not even transferring assets by operation of law, really only a change of control provision is going to be relevant because the target company is the one that survived the merger. I understand California has some kooky laws on that issue, though, and might actually treat a reverse triangular merger as an assignment of assets. So California law shouldn't surprise anybody. Always need to consult California counsel. Then remember that a subset of contractual consents are lenders and other security interest holders. They're, regardless of what the document says, to transfer the assets free and clear of liens or to otherwise satisfy the reps and warranties that are likely in your purchase agreement, seller's usually going to have to pay off or obtain the consent of the lien holders. Third-party consents can also involve regulatory issues. Obviously, this is very buyer and seller specific, but regardless of the form of the transaction, regulatory consents from governmental agencies can require a lot of advanced planning and take some serious time. Hart-Scott-Rodino generally requires a 30-day notice period if you have a large transaction involving larger companies. If you're in a specialized industry like utility or telecom or an insurance company or a bank or anything like that, you might need regulatory approval of a federal or state agency such as FERC or Iowa Insurance Division. Sometimes there's telecom deals, utility deals. I mean, this can take years. And then there's CFIUS. So if you're selling certain type of assets, drone parts, other Department of Defense type items, or you're selling a company that manufactures or holds those types of assets, and you have potential national security issue, which, as you can imagine, is interpreted very broadly by the federal government. You may need CFIUS approval. and CFIUS is control foreign investment in the United States. Now we've got really the fun stuff. So what internal consents are you required to obtain in an asset acquisition and these other acquisitions? In an asset acquisition where you're selling substantially all the assets of an Iowa corporation, here it really is going to make a difference between what the target company is, whether it's a corporation, LLC. And you're selling substantially all the assets, and that in Iowa means at least 75% of the seller's ongoing business is being sold. The seller's board must approve the transaction, and it's going to have to recommend to the seller's shareholders that the shareholders approve the transaction. The notice, assuming you can't just do consent minutes, the notice to the shareholders has to be provided indicating that the disposition of substantially all the assets is going to be brought to the vote. Unless the articles or bylaws or shareholder agreement or the board recommendation requires a greater vote, an asset acquisition requires the affirmative vote of the shareholders at a meeting where at least a majority of the votes are present. So you need a quorum, and then the majority of the people there have to vote. The majority of the shares present have to vote for it. Appraisal rights, which is Part 13 of the Iowa Business Corporation Act, are applicable in the sale of substantially all the assets. So there's certain notice requirements and dissenting shareholder rights under the IBCA, and I'll discuss appraisal rights at the end. But that's a pretty large consideration in determining how you want to structure things. If the asset acquisition involves a target LLC, so substantially all the assets of an Iowa limited liability company are being sold, the LLC's governing documents really need to be consulted. As most of you know, I'm sure, the Iowa Business Corporation Act, for the most part, says thou shalt do these things, and you can amend a few of those provisions in your bylaws through a shareholder agreement. Whereas IROLCA, on the other hand, Iowa's LLC Act, basically says, here are your default rules. You can change them with all this stuff, unless we've prohibited you from doing it under 489-110. So the governing document, in almost all cases, the operating agreement, is going to be what you need to look at to determine what kind of approval is required. If the LLC is manager managed, you're probably going to want manager and member approval. Again, the operating agreement is what's going to control. In the if there's no operating agreement out there, and you can't figure out, and you have to look at the statute, in a manager-managed or a member-managed LLC, the consent of all of the members is required for the sale of substantially all the assets. That's under 407. And then regardless of who the target is, the buyer's board or the managers in LLC or the members usually must consent to an acquisition simply because it's a material transaction for the buyer. In a stock acquisition, again, you're purchasing directly from every stockholder, so there's no per se stockholder consent you need to go get. But of course, you do need to get the approval of every single stockholder who's selling to you. The seller's board is going to need to consent if the seller is a party to the stock purchase agreement. And you usually need the buyer board consent. In an LLC, instead of a corporation, a manager consent from the buyer is likely required again. And if you're dealing with a seller LLC and they're going to be a party to the purchase agreement, you'll also need the seller's managers to approve it. I guess one point of note in an acquisition for an LLC is just that since this interest of an LLC is still kind of ill-defined, what a membership interest is, at least relative to what stock is for a corporation, make sure you use the governing documents of the target company to properly indicate what you're obtaining. Assuming this is the transaction, make sure you obtain the entire membership interest from the person selling their LLC interest. You don't want to accidentally obtain only the transferable interest or some other limited rights, which mean you might be cut off from information rights, voting rights, things like that. Only have the right to distribution and proceeds. This stuff gets really interesting. So a merger, as we talked before, can be preferable to a stock acquisition because unlike a stock acquisition where basically every shareholder is required to vote unless you have a short form merger afterwards, a merger usually requires a majority vote of the owners of the seller. The governing documents of the seller, though, can change this. If you're a corporation, you could have class voting rights, something like that. Or in an LLC, you can always, again, modify the default provisions of IROLCA. So absent a provision in the articles or bylaws that give more protective rights to the shareholders, the following are what the default rules for a corporation are. So if the target seller is an Iowa corporation, the seller's board has to approve the plan of merger and recommend the merger, that plan, to the shareholders. There's similar shareholder notice requirements as when you're selling substantially all of your assets, meaning you have to indicate that one of the reasons for the vote is the merger. The notice also has to include the surviving entity's articles of incorporation or summary of the articles of incorporation. Unlike a stock acquisition, these same rules really apply to a corporate buyer. So the corporate buyer's board must also consent, and the buyer has to submit the plan of merger to the shareholders of the buyer, or if you're dealing with the subsidiary must do this, unless a bunch of conditions are satisfied. The corporation has to survive the merger. Unless it's a parent submerger, the articles of incorporation won't be changed. Each shareholder of the buyer who had shares outstanding has to hold the same number of shares, same limitations, same preferences, etc., immediately after the merger. And in the merger, if shares or securities convertible into buyer shares are provided as consideration for the seller, then it can't trip over this majority vote requirement of shareholders under Iowa Code 621, Section 6, which basically says if you are issuing 20% or more of the voting power of shares, then you still need a shareholder vote if you're a buyer. Obviously, that's confusing. Separately, if a shareholder is going to be subject to personal liability for any obligation of the buyer or any other person, the approval of the plan of merger does require the shareholder, and each individual shareholder might have that liability, to approve it. Similar to a sale of substantially all the assets, Iowa Business Corporation, if you're dealing with a corporate seller here, does provide appraisal rights to dissenting shareholders. In an LLC in Iowa, absent provisions in governing documents that are to the contrary, all of the members must approve a merger from both the buyer's side and the seller's side. Obviously, it's not uncommon to change this requirement in an operating agreement, but if you don't have an operating agreement, that's your default rule. Even though it's common to change that in an operating agreement, IROLCA says you cannot restrict the right to approve a merger under Section 1014 of IROLCA to a member that will have personal liability with respect to the merged organization. So in all events, regardless of what the governing documents say, a member of the LLC, similar to a shareholder in a corporation, if they're going to have obligations or liabilities of a person or entity going forward, the specific member, the specific shareholder are going to have to approve that. So in a merger where somebody dissents, or in an asset acquisition where somebody dissents and they had voting rights, and the seller is a corporation, the dissenting shareholders are going to have appraisal rights. These provisions aren't applicable in an LLC, although I suppose an operating agreement could include appraisal rights in the governing documents to make them applicable. I'm not sure I've ever seen that. So a shareholder who's a stockholder is going to be entitled to appraisal rights if there's certain mergers, in certain share exchanges, which we don't really discuss here, sale of substantially all the assets, in a reverse stock split where where less shares are issued than what were outstanding to cash out certain of the shareholders, or even in a conversion where you're converting the entity type jurisdiction. In general, a shareholder is going to be entitled to appraisal rights, which gives them the right to obtain fair value of their shares. In a merger situation, if the shareholder approval was required for the merger, and if the shareholder was entitled to vote on the merger. A couple carve-outs are public companies, so New York Stock Exchange, that sort of thing, since the person will be getting public company stock in that instance. And the corporation performed a parent submerger. In Iowa, if a corporation owns 90% of its subsidiary, the board of the parent can simply vote to approve the merger. I don't really want to get into full discussion of appraisal rights in this presentation. I want to leave time for some questions. Just want to call your attention to a couple provisions though. If a proposed corporate action, such as the ones on this slide here, is to be submitted to a vote at a shareholders meeting, remember that the meeting notice has to state that the corporation has concluded that the shareholders are or are not entitled to assert appraisal rights. And if the appraisal rights are or might be available, you need to include a copy of Part 13 of the IBCA with that meeting notice. There are subsequent notice requirements too. So in a parent submerger, the parent corporation has to notify in writing all record shareholders of the subsidiary to assert appraisal rights. And those are just sent 10 days after the corporate action becomes effective. You don't have to do that prior to getting as part of the shareholder notice for the vote. After an action given appraisal rights become effective, a certain notice and form has to be sent to the shareholders. That's under 1322 of the Act. Again, I want to give you guys time for questions, so I haven't got too much into appraisal rights here. It just can be appraisal rights will permit you to go forward with your acquisition transaction fairly swiftly, but you're going to be dealing with trying to cash out for fair value to sending shareholders on the back end. I went through that a little bit more quickly than I anticipated. Hopefully there's some questions out there. Chrissy, I'm sure will help me with my chat box here.
So far, I didn't have any questions, but let reminder. Just a reminder that if you want to ask a question at this time, you can type that into the chat box, and you'll be able to ask a question. Do we have any questions? Michael, do you want to cover anything else? We may give them time to type anything in that they want to ask.
We have a question. How does due diligence affect the structure of the merger, especially where the parties may have already settled on a structure? Thanks. That's a good question, and something I probably should point out from the beginning, which is if your client comes to you and says, "Hey, we're doing a stock deal and we want to close next week," which is about the amount of time they usually give you, you always want to step back and have a conversation with them about why they are doing a stock transaction. It's not uncommon, especially even the most. I would say it's not uncommon even for unsophisticated clients, but even for sophisticated clients who are used to running their business and are not in the world of acquiring companies or being acquired, people will come up with their transactions based on a Google search, or maybe they only know a stock acquisition is even available. So do have the conversation with your client and retrace the steps. I mean, do it in a non-offensive way about, does a stock acquisition really make sense for you in this instance? Does an asset acquisition really make sense for you in this instance? Here are the tax considerations and risks. Here are the commercial issues. What are the reasons why you guys decided to do a stock acquisition? And sometimes there are legitimate reasons. The primary agreement we need to keep just as an anti-assignment provision doesn't have change of control. Due diligence can certainly play into that part. What license can the target company keep a license if it undergoes a change of control, whereas it might not be able to transfer that license? See that not infrequently in some states like California or Louisiana, where you really cannot transfer the license, but a change of control doesn't affect you. If at all possible, I guess the answer is use due diligence to help structure the merger, stock acquisition, asset acquisition. At least have those conversations up front about what you might be getting into, and leave yourself some flexibility on the back end. All right, another question. How do you work through valuation issues when a buyer is thinking asset purchase and the seller is thinking something like, write me a check for 4 times annual recurring revenue? I mean, that's a really good question. From a very basic standpoint, obviously the parties need to come to kind of a meeting of the minds on what the valuation is going to be. I'd say you can still do an asset acquisition when the valuation is based on EBITDA or multiples of revenue or whatever. It becomes a little bit trickier when you're considering the reps and warranties, and when you get into due diligence and you're thinking about, okay, well, this issue came up, how is that going to affect the purchase price? In my mind, that's where those discussions become difficult, because we wanted 4 times the revenue, but now I have to put $500,000 in for a new piece of equipment. How does that really affect my revenue going forward? I think the most important thing is for both parties to have a clear understanding. It's almost always the buyer who comes up with the valuation method. For the seller to have a clear understanding of what the buyer's valuation method was, so that if in due diligence other issues arise that might affect the purchase price, that the seller isn't surprised by what the buyer is asking for.
Do we have any other questions? If you have a question this time, you can type it in the chat box. 5 people are typing in questions. I'm going to go ahead and remind everybody of the activity ID number. It's 204290. That number again is 204290. Do we have any additional questions at this time? If you do, you can type it in the chat box.
Quick.
Wait, one.
Got another question here. What are the most critical reps and warranties? I like that question. I'd say that the most critical ones are what are most critical from a buyer's side, obviously, to your buyer client. Every deal is going to be different. So after doing the due diligence, knowing what specific assets are the most important in the acquisition, knowing the valuation and what the buyer is expecting out of the deal, that's going to drive what the most important reps and warranties are. From a buyer's perspective, you don't always get this, but maybe the most important rep and warranty is, it's called the 10b5 rep and warranty, where basically at the end of the representation and warranty section, you're saying there's no material omission or material misstatement of fact that would make any of the reps and warranties misleading. Now that catch-all is obviously disfavored from a seller's standpoint, especially if they've already gone through 30 pages of specific reps and warranties and schedules to have a catch-all that basically says, and cover anything else you can think of. But that rep and warranty is going to cover the waterfront for you from a buyer's perspective. If you're acquiring intellectual property, that's your primary asset, a rep and warranty around non-infringement is going to be the most important to you. It's a stock acquisition. Things like knowing the capitalization of the company are always going to be very important. But other than that, it's really going to be very much around, what does this buyer want, and what are the most important assets or the most important parts of the business going forward.
If we don't have any more questions at this time, I'm going to remind everybody one last time for the activity ID number. We have another one popped up.
The question is, what kinds of issues do you insist cannot be covered by a post-closing memorandum? Just so everybody knows, post-closing memorandum in an asset acquisition or any other acquisition, there will be a number of closing conditions in your purchase agreement. And sometimes some of them are not going to be able to be achievable at closing. The buyer still wants to proceed to close, but still wants a seller to perform those obligations after the fact. I think, like reps and warranties generally, this is very deal specific. I guess I've seen post-closing memoranda that include things as important as transferring assets, obtaining lien releases, things like that going forward. But something like obtaining the release of the primary senior creditor on all of the assets in an asset acquisition I can't imagine a situation where that's going to be helpful. You're never going to be able to push regulatory approvals to a post-closing memorandum because you're going to need to get those ahead of time. You're not want to take that risk. But for the most part, it's really going to be deal specific. What is the buyer? What on a case-by-case basis is a buyer going to be willing to risk with closing over and paying the purchase price, but still leaving some of those closing conditions out there?